Good afternoon and welcome everyone. Thanks for joining us today on this Thursday afternoon. My name is Neetu Gill and I will be today's moderator. I am the project coordinator here in the Research and Court Services Division at the Office of Court Administration. As you probably know, the Research and Court Services Division hosts a webinar each month, and today's topic will be the role and responsibilities of the court coordinator in a child support court, Part 4. Today we will be doing Part 4 of this 5-part mini-series. If you were not able to view Parts 1, 2, and 3, that will be sent out in a Dropbox after this webinar. Perhaps you probably already viewed it in a previous, webinar. Prior to beginning, I just want to go over a few housekeeping details. Please mute your microphone. If you do have a question, please use the chat box to the right-hand side. I will be monitoring the chat box throughout the webinar. If there is a technical question, we will address it immediately, and questions pertaining to the presentation will be addressed at the end of the webinar. And if you don't mind, just let me know if you guys can hear me. I'm assuming you can. Without further ado, I want to introduce today's speaker, Ms. Aurora Zamora. Ms. Aurora Zamora is employed with the Office of Court Administration as a court services consultant. As a consultant, she offers technical assistance to courts in court management, case management, and processes. And she also provides training to court personnel and court clerks. Aurora, welcome. Thank you for joining us today.
Hello, you all. How are you? Welcome. Hopefully you took advantage of sections 1, 2, and 3. If you did not and you're a seasoned court coordinator, maybe you want to go back and view some of them. Hopefully you'll find 1 or 2 slides useful. Today's part 4 is the second to the last webinar. I would encourage you to attend all 5 or to view all 5 of them at your convenience. Neetu is going to take me off camera, so I'm not distracting, and we will proceed with the webinar. The role and responsibilities of a court coordinator in a child support court, Part 4. These webinar series, they'll give you a good background from which to grow and expand your knowledge skill set. As I said, if you're a seasoned court coordinator, you may have just opted to skip the first 3 sessions, and that's okay. At some point, again, I do suggest you review them. You may find 1 or 2 slides helpful. So let's talk about how we determine child support cases and what actually gets them started. As you know, child support establishment or enforcement cannot begin until the parties are identified and confirmed by a judicial proceeding. All of you are familiar with the DNA and the exclusion or inclusion of parents through the DNA process, and your phlebotomists that are sometimes at the courthouse. So I'll give you a chance to read through this. Our source is, again, the Family Code, Chapter 160. So some of the terms that you will be hearing is the genetic or DNA testing, and that marks genetic markers that exclude or identify a man as the father of a child or a woman as the mother of a child. We have an adjudicated father, a man who's been adjudicated, determined or confirmed by a court to be a father of a child. We have the presumed father, a man who by operation of law is recognized as the father of the child until that status is rebutted or confirmed in a proceeding. We have the acknowledgement of the paternity, that's the mother of the child, and a man claiming to be the biological father of the child. They sign an acknowledgement of paternity with the intent to later establish the man's paternity. We have the denial of paternity, and that's when a presumed father may sign a denial saying, no, I'm not the dad. And we have the rescission of the paternity, and that is when they either say, yep, that's my child, or no, that's not my child. So let's talk about how we get started on this. The acknowledgement of paternity is one most often seen at the beginning of the case because this is usually done at the hospital when the child is born. The hospital is a recognized, certified acknowledgement of paternity center. So the child is born, mother and father sign a form that says, "This is my child." Remember, we can later deny it or rescind it. The process of determination is complex in many phases. Some of these proceedings can become very emotional for both parents. In the case of the presumed father, the one who's been recognized by operation of law, the father, sometimes after DNA testing is done, he's excluded or determined not to be the father. This can be a very emotional event. We will talk about security in the courtroom in our last session or the next webinar. However, this event is one when you will want to have a bailiff on alert. A father who has just been notified that the child he has raised for the last 3 or 4 years is not his can become volatile. So place your bailiffs on alert. And remember, we talked about confidentiality. Well, this section of the Family Code speaks to the protection of participants and their privacy for proceedings under this chapter. So if you know the parties and you find out Joe Blow is not the father, don't gasp and call your friend and say, "Guess what? He's not the father." This is confidential. So we're jumping a little ahead. Types of commitments after the father has been either acknowledged or determined to be the father and maybe falls behind on child support payments. We then bring him back to court and sometimes enter a deferred commitment. And that is when the non-custodial parent is ordered to pay child support either in a lump sum or a lump sum and monthly payments by a certain date. So the non-custodial parent has come to court on January 15th and may be given 60 days, March 15th, to come up with a lump sum and get back on track paying the child support. When the non-custodial parent does not comply with that order, the parent may be found in contempt of court. The contempt of court action may result in a term of commitment in a jail until a maximum of 6 months, payment of the ordered child support, plus a fine of $500. If the non-custodial parent comes and pays the child support, then the court suspends the commitment and sets it aside. So let's talk about deferred. The term deferred refers to commitment that is being postponed or delayed until a certain time. It's a promise to pay by that date. When the court enters a deferred commitment order, one of 3 things will occur. The non-custodial parent complies with the order and the court suspends the commitment. The non-custodial parent then resumes making payments as outlined in the order. The second thing that can happen is the non-custodial parent fails to comply with the order and the court enters a commitment order and remands or takes the person into custody. The third thing that can happen is the non-custodial parent fails to appear. Maybe I know I don't have the money, so why go? You're just going to arrest me. Well, the deferred commitment then becomes the instrument for a capias or a warrant of arrest for failure to appear and the arrest of the non-custodial parent. When the last occurs, the non-custodial parent will be arrested just as any other individual with an outstanding warrant. A magistrate, if your county uses justice of the peace, will often try to set a bond of release and appoint an attorney for the now incarcerated parent. as they usually do when they magistrate criminal defendants who are in custody. Remember, the bond amount is not at the discretion of the justice of the peace or magistrate. It is the child support amount ordered plus the fine. And remember, the non-custodial parent already had the benefit of an attorney appointed to represent him or her before they even entered into the deferred commitment order. Remember that an attorney has been appointed to advise the parent who is promising to pay by a certain date and time. The parent had a right to be represented throughout the contempt proceeding if the parent is indigent, and the hearing would have likely resulted in incarceration. So we've already had an attorney appointed. Your responsibility is to get that case back on track at the first available docket. Normally, the jail will release the parent on a conditional release order with a date to appear. The conditional release order is supplied by the OAG to the jail. Remember, in your role, you provided the OAG and the jail with a court calendar. They will refer to your calendar in determining the next court date available. It is vital that you maintain good communication with the jail personnel and receive accurate reports on who they arrest from your court. Whether the person is released or remains in custody, make sure this case is included on your next court docket. So your calendar will be reviewed by the OAG and the jail, and they will see that your next available court date is either in a week or maybe as soon as tomorrow, but they will add that case back on your docket. Another thing to remember is the incarceration time can be a maximum of 6 months. So it's very important for your court to keep track of the total amount of days this parent has been incarcerated throughout the life of the case. From part 3 of the series, there was a question on the disposition and setting of deferred commitments. I will address that question now so that everybody can benefit from the explanation. You dispose of a case as a deferred commitment. You can then set a future date and the case will show up as disposed but active, as in it's been closed but there's still some action on it. All 3 of the actions we discussed earlier, suspended commitment, commitment, and Capiases are available under the supplemental orders. If you use CSCMS, that was specifically designed because the advisory committee knew that the deferred commitment was a disposal, but something else always followed. So let's say the non-custodial parent is resuming to make payments or has agreed to a certain payment on an order to enforce or an order to modify. The AG's office has closed this case. But some judges use compliance hearings for informal check-in or status hearings. They just bring the non-custodial party and ask them, how are you doing? Are you working? Are you paying? Why aren't you paying? Is the amount too high? Did you lose your job? These hearings usually follow an order to enforce or order to modify child support. The non-custodial parent has had difficulty paying, but when prompted, seems to stay on track. Some judges use compliance hearings in lieu of probation. Some judges use compliance hearings as teaching tools for new parents with child support cases who maybe are thinking, hey, we'll get an order entered, I'll commit to a date, and then I'm free to go. No, the court will keep monitoring you. So we have a poll question now. The question, which you will see on your screen, is, does your court conduct compliance hearings after child support has been ordered? Your options are yes, no, I don't know. So we'll give you all time to think about that and answer the poll question.
Let's keep it open. Excuse me. Let's keep it open for about 10 more seconds. Okay, well, I'm going to go ahead and close the poll right now. So 86 of our attendees said yes, 0% said no, and 14% said I don't know.
Good job. These hearings are time consuming sometimes, but they are very effective. So let's go on. Let's talk about the non-custodial parent that didn't show up. So the non-custodial parent has failed to show up, and a capias has been issued. It is a warrant for, remember, contempt of court, failure to appear. Until it is served, the capias stops the aging of the case. The served capias results in the person being incarcerated in the county he or she was arrested. The sheriff of the county where the case is filed will transport the person back if the arrest occurred in a county other than the county issuing the capias. So I'm in Travis County, and let's pretend I'm a non-custodial parent who had a capias issued in Travis County. But now I have traveled to Bexar County, San Antonio, and I am arrested in Bexar County. Travis County will then have me transported back to this county to go before the court that ordered my arrest. In a case, in the life of the case, there may be more than one capias issued. It is important that you utilize whatever software you're using in the county where the capias is issued to track the activity of the capias. For example, the date the capias was issued, when was the capias served or the person arrested, the amount required for a person to be released after arrest, was the person released after the arrest, was a hearing held afterwards. Use data reports to track those capiases. We will talk more about data reports in the next webinar. On a case-by-case basis, remember to record the number of days the person was incarcerated. And I know most of you are familiar with this, but if you are new, don't be surprised if the first phone call you receive after the arrest of the non-custodial parent is a call from the custodial parent or mom. Often, the custodial parent will join with other family members to pay the child support due, plus fine to release the non-custodial parent. Remember, these calls need to be referred to the OAG. The OAG is the one to initiate any conditional release of the arrested person when the bond, child support due, is paid, or if another amount is agreed to. Refer all inquiries to the OAG. So let's talk about specific cases. One type of case that you will have is a case which has been flagged a domestic violence cases. These are very sensitive cases. Domestic or violence, family violence can be intimate partner violence or spousal abuse. These behaviors include physical, sexual, financial abuse. Ironically, these behaviors make a victim more likely to stay with or return to an abuser due to fear of retaliation or need for financial stability. Federal welfare law requires states to implement safety measures when addressing family violence indicators and the child support cases. So when the OAG tells you there's a domestic violence and they flag it, know that they're only following federal welfare law requirements. In Texas, the LBJ School of Public Affairs did a study on child support cases in which family violence existed. And these numbers have dramatically increased since the 1990s. It found that the high number of domestic violence was experienced by unwed mothers, particularly during the pregnancy phase. It also found that 30% of the custodial parents with formal child support orders have experienced domestic violence. So those are parents who have formal child support orders. They know who the father is. The rate is 37%. 43%, it's increased some, those that have no formal child support orders who have experienced domestic violence. And then they found that 90% of women who have experienced domestic violence would pursue child support if they could do it safely. We often tend to dismiss cases which are identified as family violence or domestic violence because we see the parties sitting together or leaving the courthouse together. Remember, the custodial parent often participates in this appearance of closeness or friendliness out of fear, financial need, or just a desire to reestablish a parental relationship for the child's sake. We will discuss court security measures and how it relates to domestic violence in the next webinar. So domestic violence and the OAG. You've heard them and you've seen their docket. They have indicators. The states are required to place FVI on child support cases in which a party has made an outcry and they need personal information protected due to risk-related domestic violence. That, in conjunction with the Federal Parent Locator Service, all of you know of this. It is the service that collects and stores information and has the ability to share information about parties with child support cases. It matches the information daily with multiple agencies, excuse me, in order to locate parents for the purpose of establishing and enforcing child support orders. This is the locator service that finds where a non-custodial parent is working so that child support can be enforced. When the OAG has indicated that a case is FVI, that will trigger confidentiality safeguards within the FPLS, which will restrict the release of all information about the victim. So home address, emails, phone numbers, all of that will be safeguarded. So let's talk about domestic violence in your court. We talked about the OAG and what they do. Let's talk about what you can do. The reason some victims don't trust the court is because they had a previous negative experience. A lot of them don't think that the court understands domestic violence. You don't know what they're having to go through, or they may just fear for their safety. So in your role, think about these fear factors, about reviewing them or eliminating them in your court. Delays or continuances. The more that you continue a case, the longer they have to endure this fear. Lack of knowledge of court procedures. They don't know what is going on. They don't know that a DNA test can be requested. They don't know why it's being continued. So make sure that you either connect them with an OAG representative, that if they have any questions, you try to help them. Not giving legal advice, remember we talked about that, but procedural information. And sometimes this fear comes because the abuser has given them misinformation about the court system. They try to scare them with different tactics to keep them submissive to them. Requiring the victim to cooperate with the abuser or to have regular contact is one of the things that we really need to be mindful of when they're conferring Make sure that they don't confer together because that misinformation or that fear can continue. Make sure you have the space, that your bailiff knows that those are domestic violence cases and that those parties need to be negotiating apart from each other. And sometimes they just don't understand because there's a language barrier. So be sure and provide an interpreter in those instances. If you need more information on domestic violence, here are some really good resources. Look at them. They have additional guidance for you. So the parties came to court. There was an outcry of domestic violence. And now the judge has ruled that there is risk or safety to the custodial parent or the child. So the OAG will often request a finding of family violence, and or they will request an order of non-disclosure. The order of non-disclosure just means whoever is in charge of my records, please redact, erase, remove any information about the residence, where the party lives, where the child goes to school. Please remove that. And that is under the Family Code, Section 153. So here's something that if you are new to the courts, you might be surprised, and you may not know this, but this is how you can help. The order of non-disclosure is not a standalone order. You won't see an order to modify or enforce and then another document that says order of non-disclosure. No, the order of non-disclosure will be instructions that are often embedded within the final order. Make it a practice to identify the cases marked with FBI, and when the final order is signed, bring that non-disclosure to the attention of the clerk. The instructions are sometimes as far as 10 pages within the document. The clerk may not even notice that he or she is ordered to delete or redact all references as to residents, phone numbers. These orders should serve as a reminder that you work with sensitive information that should not be shared with anyone. In these cases, information shared can often place the parties in danger. So we're going to continue into another type of case, and these are some that are UIFSA's or Uniform Interstate Family Support Act cases are complex, and hopefully these slides will help them. Maybe they'll make them a little bit clearer for us. So the Family Code 159 talks about 3 different locations. It refers to state, which is domestic. That refers to any states within the US, the District of Columbia, Puerto Rico, the Virgin Islands, and any other insular possession that is under the jurisdiction of the United States. It also includes Indian nations or tribes. It talks about a home state, that is a US state or a foreign country in which the child has lived with a parent or a person acting as a parent for at least 6 months prior to the filing of a petition. And then it talks about a foreign country. That is a country or a political subdivision other than the US that is authorized to issue child support orders. It's declared under US law to be a foreign reciprocating country. It's established state reciprocal arrangements for child support. It's enacted laws or established procedures for issuance or enforcement of support orders. And it's countries who have participated in the 2007 Family Maintenance Convention. You can find all this in Family Code, Chapter 159. UIFSAs are complex and rare. As a coordinator, you may not even notice them. That's because the process occurs mostly off-site until the OAG is required to file the petition. Some enforcement orders in Texas from another state may be done administratively and never filed if an agreement is obtained. The Uniform Enforcement Family Support Act was amended in 2008, and it requires the U.S. states and foreign countries to cooperate in the enforcement and the collection of child support. Prior to the amendment of 2008, this process was difficult because it involved different state laws, procedures, and agencies. Think about it. After 2008, that was when our military was most active and in foreign countries. So this probably prompted a lot of these amendments. The new model law changed interstate child support enforcement to a one-order world, establishing rules that restrict when a court in one state could establish a new order, and it limits the authority of a court in another state to modify a valid support order entered in a state. Additionally, in 2014, President Obama signed the Preventing Sex Trafficking and Strengthening Families Act, which now requires all states to have the same version of UIFSA. This went into effect 2016. So if you've been in your position as far back as 2008 and you've seen the difference in these orders, you can appreciate that act that was passed in 2014. So here is a slide that maybe will help you understand what is going on. In the image at left, California, Texas, and Oklahoma can either initiate or respond to a UIFSA. It's the cooperation of all state child support agencies in the U.S. or its territories to enforce child support across state lines. It requires an initiating or issuing state. It's the state which issues the support order or a judgment determining parentage. The responding or receiving rendering state. It's the one where the petition or the pleading is filed and forwarded from another state. The designation is determined by the residence of the parents and or the child and the state who is controlling order that governs the current child support. So let's say the non-custodial parent lives in California and the mother and child live in Texas. Texas could then petition California for child support across state lines if the mother had resided in Texas more than 6 months with the child. So that was in the states or domestic. Let's talk about a foreign country. Remember, we talked about two different countries. The foreign country, which is declared a reciprocating country. As of 2016, the U.S. declared 26 reciprocating countries. The image to the right shows that Texas and Canada are reciprocating countries. Convention refers to those countries that have ratified the Hague Convention or the 2007 Family Maintenance Convention. Application for those countries have to be done through the U.S. Department of Health and Human Services. Countries who have not ratified the Hague Convention are considered non-convention countries. So the U.S. or Texas, where your court would be, would have to consider Afghanistan a non-convention country. It's outside the USA. It defines a location other than the U.S., whether or not the country is a foreign country. UIFSA process is complex enough when it's within the U.S. borders or territories. The 2008, the amendment to UIFSA guidelines focused on international child support. These guidelines also included the requirement for the initiating child support agency to convert child support payments into the equivalent amounts in dollars under the applicable exchange rates. So now we've made it even easier. So what does all this have to do with you and your court? Remember, we said most of it happens off-site. Well, sometimes these cases involve one or more parties who are hundreds of miles away, and the OAG and the UIFSA law address the lack of appearance. So it requires that the deposition, or it allows deposition and testimony to be permitted to be done by phone, fax, or other electronic means. It allows for certified copies to be considered as original documents. And it allows that a court may not exclude the documentary evidence transmitted by fax or electronic means when the original document is not provided. Courts in Texas and any other state or foreign country may communicate by fax, phone, or other electronic means to obtain information, affect the legality of judgments, the decree or order, and obtain the status of this proceeding. Remember, in your role of matching administrative processes with judicial processes, the UIFSA law allows you the opportunity to excel in your responsibility to do this. Ensure that your courts, your conference rooms, and/or offices are equipped with the necessary equipment, such as fax machines, telephones, video conference capability. Make sure that if you're outside your county or even in your county, make sure that your court has the ability to make out-of-state calls if the court is initiating the call. Discuss these processes with your judge for direction on handling telephone requests from out-of-state litigants, and be sure to notify all parties involved in these processes. So another type of case is those that involve military parents. And again, because of 2001, we have many more non-custodial and custodial parents that are serving in the U.S. military. This will give you an idea of what the OAG has done. They've created heroes. They work with JAG, the Family Readiness Group, the Veterans Integrated Service, the Texas Veterans Leadership, the Yellow Ribbon in Texas, and other child support and legal services. They've also published on their website military parents, paternity, child support, custody, and parental time. The link allows you to go directly to that publication. Some parents deployed or in active duty also seek assistance or protection under what is called the Service Members Civil Relief Act of 2007. It formerly had another name. Protections under this act are not automatic. The parent must request protection or relief. So if you have a non-custodial parent that is calling you from overseas, from their deployment, refer them to the OAG, because this act is not automatic, and the OAG is the best to identify the different processes and the time frames for those already deployed and those just informed of the deployment. And that concludes our part 4. I hope that you all have questions. We'll give you a minute to think about them, type them.
Thank you, Aurora. That's a great wealth of knowledge of information. While people are thinking of questions, can you share if people want to find information about this? Can they find it on our website, or who can they reach out to?
Most of the resources that I obtained this information from, that was a bad sentence, have been given to you and are on this webinar. Our last slide has the contact information for both Ms. Anissa Johnson, who is the program manager for all of the specialty courts, now called children's courts. And then you have my number and my email, so you can always reach out to me with any questions, and I will try to specifically answer your questions. And like we did with the deferred commitment, I will also try to answer them during the webinar, because they the information is useful for all of us. Do you have any?
Great. Well, thank you, Aurora. Appreciate it. Before everyone logs off, and if you don't want to pose your question now, no worries. That you will receive a survey/evaluation right after this webinar, and also in a follow-up email. Please, I encourage you to fill that out. It helps us evaluate the webinar and do better for the next one. And if you do have a question, please feel free to utilize that comment box in the evaluation to ask your question, and I will get that. Make sure it gets to Aurora so she can address it. And send an answer to you. And with that, I just want to say thank you once again for joining us. I will send the PowerPoint and this webinar recording in a Dropbox link. I will also attach the previous two webinars. Part 1 and 2 was combined, and part 3 was a standalone webinar. I will make sure that those PowerPoints and webinar recordings are in the Dropbox. And we will have these on our OCA website pretty soon, so be on the lookout for that. Thank you, everyone, and have a great afternoon. Bye.